Thank you.
SJC-10940, Commonwealth versus Gonzalez.
Yes, sir. Good morning.
Good morning. Jeffrey Baylor for Mr. Gonzalez. Here we contend, as the Commonwealth concedes, that the instructions related to manslaughter were erroneous.
Well, the Commonwealth doesn't really concede that as to the self-defense instructions.
I believe, in terms of them being erroneous, I believe the Commonwealth does concede.
Well, maybe I'm mistaken, but I thought that they said that
The Commonwealth argued that the evidence wasn't sufficient, therefore there shouldn't have been manslaughter instructions.
Actually, what do you say was in error with regard to the instruction concerning self-defense or excessive use of force in self-defense?
Well, at first, the instructions would not even have permitted the jury to consider manslaughter under self-defense or any of the other theories. The jury was instructed that these are the three elements of first-degree murder. If you find them, then you should return a verdict of first-degree murder. There was nothing that told the jury that manslaughter could mitigate first-degree murder. For example, in the model jury instructions, they say you can find first-degree murder, except you must consider whether it is mitigated by the three theories of manslaughter. So at first, we contend, based on those instructions, the jury would not even have reached manslaughter. They would have said, yes, we have the three elements of first-degree murder. The judge says we should return that verdict. And they never would have known that they needed to think about whether this murder was mitigated to manslaughter. And even if they did reach the manslaughter instruction, the exact opposite burden was given. When the possibility of manslaughter arises, the Commonwealth has to prove beyond a reasonable doubt that the mitigation wasn't present, that there wasn't excessive force, that there wasn't reasonable provocation or sudden combat.
Yeah, but actually, no. I mean, if you turn to page 40 of the blue brief, which is
Yes.
the written instructions, which I assume mirror, he doesn't mention there excessive use of force. He mentions reasonable provocation or sudden combat. And I grant you're correct as to that. But when he discusses excessive use of force, that's on page 38. If the Commonwealth proves beyond a reasonable doubt that Louis Gonzalez used excessive force in defense of himself that caused the death of Jennifer Morales, then you should return a verdict of guilty of voluntary manslaughter based on excessive force. Are you saying that that's an error?
You're saying at the bottom on page 38?
Bottom on page 38.
If I could just take one moment to read it. Yeah, I'm saying that that shifts the burden because it's saying that the Commonwealth has to prove beyond reasonable doubt that Mr. Gonzalez used excessive force.
Oh, I'm sorry. Okay, so it's the proof beyond reasonable doubt portion.
Right. So it's exactly the opposite. What should have been said was the Commonwealth must prove beyond a reasonable doubt that excessive force was not used, and that's the Acevedo case. From this court, exactly that language. So based on this language, we contend that, first of all, they wouldn't even have considered manslaughter, and secondly, even if they did, it was just the burden of proof was totally wrong. And beyond that, this created a substantial likelihood of a miscarriage of justice and gave rise to ineffective assistance of counsel.
Could you talk about the evidence that supported the giving of a voluntary manslaughter instruction in the first place? I mean, the Commonwealth is basically saying there isn't really any evidence that supports that, and as far as I can see, the evidence is limited to the defendant's statements either to Rivera, which are non-specific, he was being attacked by them,
Right.
and statements he made to the police,
Right. Well,
which were in no event, none of them mention the victim herself. It's sort of, the only way I think you have to understand is that somehow collectively she was part of the group of people in the apartment at the time. But there's nothing that I saw anyway that referred specifically to her.
right. I mean, the evidence shows that she was part of this group that surrounded Mr. Gonzalez. And he told Mr. Rivera, they want to kill me or they want to beat me. He told police he got jumped from a lot of people and he was only defending himself. So from that, the jury could have inferred reasonable provocation or sudden combat. It's really a question of Mr. Gonzalez's credibility, not that the evidence wasn't sufficient. And the Commonwealth cites the Commonwealth's witnesses saying that, no, this happened as Acevedo attacked Mr. Gonzalez and no one else. But Mr. Gonzalez is saying, no, I was attacked by this group and I was only defending myself. And it's clear that the decedent, Ms. Morales, was part of this group.
Here's the thing, well, okay, but I mean, on provocation, certainly, doesn't it have to be that, whether it was reasonable provocation from the victim?
Yes, it does. So we're
So
saying,
this is really, it's just pure inference that she was part of the group who attacked him.
I think from the Commonwealth's own witnesses, it's clear that she was part of this group in the kitchen.
Part of people who were present.
Right, part of the group. And then, if you believe Mr. Gonzalez, he said he was attacked by this group. He's saying something totally different than what the Commonwealth's witnesses are saying. He's saying he was attacked by this group and he was only defending himself. And the evidence shows that Ms. Morales was part of this group.
But you have the timing problem. I mean, there is evidence that there was a fight between him and Adolfo, and maybe we'll grant you that the others joined Adolfo in it. But that was about a half hour before the stabbing, based on all the other evidence. So what do we do with that?
I'm not sure if it was a half hour. It might have been less, but maybe.
20 minutes at least?
Okay.
I mean, I don't know. I mean, that's but enough time for Adolfo to have actually left, and for him to be gathering up his belongings to leave. And I don't know that there's any evidence of anywhere of any provocation or assault upon him after Rodolfo left. Is there?
Well, two things. I mean, from what Gonzalez is saying, we contend that the jury could have believed that the stabbing happened while this beating was occurring. So there would be clearly sudden combat and regional provocation if it happened while it was occurring. But even if he had left the scene, even if he had gone to his room and grabbed a knife, it would be up for the jury to determine whether or not he had cooled off or not. I mean, there's no time limit set by this court where it says if it's a half an hour, he's cooled off and there's no provocation. So it had to be left for the jury to infer whether or not there was cooling off. If they didn't believe in the first place that it happened directly when this beating was occurring. I mean, we have to look at it in the light most favorable to Mr. Gonzalez. And even though the Commonwealth's witnesses say something different, it's really looking whether the jury will credit Mr. Gonzalez's version that he was, as he said, he was jumped from a lot of people and he was only defending himself. So either way, whether it happened during this beating or whether he went to his room and came back, it had to be up to the jury to determine whether or not he would have been provoked and cooled off. And looking at it in the light most favorable to Mr. Gonzalez, they could have concluded that he, even under that theory, that he was hit. He went into his room and he got a knife without cooling off, and he came back and stabbed Miss Morales.
I mean, I guess what it comes down to essentially is whether a reasonable jury could find a reasonable doubt based solely on his statements to the police. Because I don't know that there's any other evidence that supported it. Isn't that basically what it comes down to?
There's a couple other things. He says that he told police, they asked him if he was injured. The Commonwealth's witnesses just said he had a bloody lip. He told the police that he was injured all over. I can't remember the exact words. My legs ache, my arms ache. And from that, the jury could have concluded that Mr. Gonzalez's version was supported of a beating beyond a cut lip, what the Commonwealth's witnesses said. Also,
Weren't there pictures of him too, though?
there were.
And I haven't looked at them, but I mean, I'm assuming
But
they
I
were
mean, if you-
consistent with the Commonwealth's witnesses,
But
isn't
if
that
he
right?
was bruised or if he was punched in other places, it may well not have shown up on, pictures under his clothes or, those injuries. But we're just looking, we have to look at it in the light most favorable to Mr. Gonzalez, not what the Commonwealth's evidence was. We have to say, was there any evidence here that the jury could have come back with manslaughter? And if yes, then the error occurred. It's really, you just have to either believe the Commonwealth's version or you have to believe Mr. Gonzalez's version. And if Mr. Gonzalez's version is believed, then manslaughter is supported.
Is there any case where the facts, frankly, are this slender? The evidence is this thin?
Well, I think,
Or we've said that that's enough to fit in the category of any evidence taken in the light most favorable to the defendant?
are you saying based on the situation, or are you saying based on just on the words of a defendant?
Well, the latter.
I don't know of any off the top of my head, but that wasn't really an issue that I looked into in depth.
Okay.
Because to me, it's just like if there's an inkling that the jury could have found it, that's what the light most favorable to the defendant is. We're not looking at credibility or anything. We're just looking at whether the jury could have come back with manslaughter. Oh, and one more other thing. There was a knife found on the floor of the kitchen, a folding knife, which police said had nothing to do with this, with the stabbing. But again, the jury could have concluded that there was more to the story than what the Commonwealth's witnesses said. That they could have said, oh, someone had a knife. This was more than just Acevedo coming in and punching him in the lip. So based on these facts, we contend that under all three theories of manslaughter, it was just a question of credibility, not a question of whether there was evidence or not.
I'm sorry, you say all three theories. Self-defense, I understand, but reasonable provocation by her?
Well, if she is striking him, this court's found that even one blow is enough for reasonable provocation. So if he says I was beaten by the group and she was in this group and the jury could have found that she struck him, then that would be adequate provocation. And I recall that the Webster case cited in my brief that talks about sudden combat even goes to a similar fact situation. Says if two parties are fighting each other and one leaves to get a weapon and comes and strikes the other, that's sudden combat. So based on what Mr. Gonzalez said, yes, all three theories would be supported. At least the jury should have been given the proper opportunity to consider it. I mean, the trial judge obviously thought that there was enough for the instruction. And the Commonwealth, when asked about objections, all the Commonwealth said was, Judge, respectfully, the only issue that I take with the instructions are the issue of the instruction on self-defense. the Commonwealth didn't say, I have an issue with manslaughter, only self-defense. That's in the March 8th transcript, page 538. If there's no further questions, I'd just like to briefly mention the second issue in the brief, that the statements made by Mr. Gonzalez should have been suppressed. We contend that a statement made by Officer Diaz to Mr. Gonzalez was the functional equivalent of interrogation. What happened here was,
Can I just ask, which statements, aren't you relying on those statements? Aren't those the only statements you actually have to support the argument you were just making about the instructions?
that's true, but of course, these would be admissions, and the case could have been gone in a completely different direction if they didn't have, you know, his statement saying I was only defending myself. What happened here was,
I mean, you're in a strange position, because if these statements had been suppressed, your first argument goes away.
well, maybe he could have just relied on what he said to Mr. Rivera. They want to kill me or they want to beat me. Maybe that was, you know, showing him more sympathetically, or maybe they wouldn't have used it at all. Maybe they could have said, you know, he wasn't even involved. I mean, this is an admission, and we have to look under Chapman whether it could have possibly made any difference in the case. So the case could have gone in a whole different direction if these statements weren't let in. I mean, the Commonwealth's the one who admitted them, so at least the Commonwealth thought that they weren't going to be helpful to the defendant. The defendant took what was available as a defense based on these statements not being suppressed. I mean, to get to the functional equivalent part, Mr. Gonzalez was arrested. He wasn't given Miranda rights. He was taken to the police station. He was put in the lockup. He's a Spanish speaker, by the way. Approximately an hour and a half later, Spanish-speaking Officer Diaz, accompanied by 2 detectives, went to the lockup and took Mr. Gonzalez out. Officer Diaz said, "We're going to the 3rd floor." Mr. Gonzalez didn't really say too much, and then he said, "These detectives want to talk to you about the incident."
At what point was it that the police officer said, now is not the time to talk, that we would be talking after BCI has done what they needed to do?
That was
That before or after?
That was after he said, "I want to talk about the incident," but before he made the statements.
Well, weren't they telling him not to talk?
Well, I mean, we contend that that's where they should have said, "Oh, you want to talk? Here's the Miranda warnings." In the D'Entremont case cited in my brief, that's exactly what happened. The defendant said, "I'm going to talk," and out of abundance of out of caution, they gave the Miranda warnings. So, just saying you don't want to talk doesn't tell the defendant what needs to be told through the Miranda warnings. I mean, Mr. Gonzalez may well have believed, "Oh, I'm going to help the police. I want to tell my side of the story. I know they're not saying now's not the time, now's not the time, but I'm going to be the most helpful I can be. I'm going to tell them now." And they're here. Officer Diaz said these guys want to hear about the incident, and he's off and running. I mean, instead of saying now's not the time, they could have just as easily given him the Miranda rights. And once they gave him the Miranda rights, in fact, which was another hour later, 2.5 hours after the arrest, he said, "I want a lawyer," and that was the end. If there's nothing further, I rely on my brief for the
Thank you,
remaining
Counsel.
article. Thanks.
Good morning. May it please the Court. Jane Sullivan for the Commonwealth in this case. As far as the motion to suppress, the motion judge correctly denied the motion. Diaz was the officer responsible for transporting the defendant to booking and then to the detectives involved in investigating the case to see if he wanted to talk to them. When they're on the elevator, he tells them that's where he's going, and the defendant says, "I want to talk to someone." Diaz says, "Now's not the time to talk." Defendant then continues to try and talk, and the motion judge found that Diaz at least 3 or 4 times told him, "No, now is not the time to talk." The judge found that Diaz's statement, "I'm bringing you up for booking and the investigators want to talk to you about an incident," was an introductory remark. The cases cited in my brief support that finding, and the statements were admissible. And it is true that those are the statements, and the statements are precisely, that those are the statements that the defendant primarily relies upon in saying that that they create the grounds for instructions on reasonable provocation and mutual combat. The problem with that is they offer absolutely positively no context. They just say that he was jumped. They tried to beat me. If I can just, let's see. He said the defendant was crying, appeared a little sad. His clothing had a little blood on it, but the officer did not notice any cuts, bruises, abrasions on the defendant. The defendant said in Spanish he was only defending himself. Then he was stopped immediately and advised not to talk. And he kept saying that he was not the only one, stating that he was jumped, that he didn't mean to hurt anybody, and that he wanted to talk to someone regarding the incident that had occurred. And when when he brought him to the detectives and he asked to make a statement, and he was given Miranda, he declined to make any statement. The statements to Rivera immediately after the shooting, he jumps in the car, demands to be taken away from the scene. He says, they want to beat me, they want to kill me. There's a little more discussion. He said there was a fight over money. I killed the bitch. And so those statements, I would suggest, confirm that the attack on the victim, who was seated in the kitchen throughout the entire thing, she was entirely passive. She was in a little chair in the corner of the kitchen.
Well, that's the Commonwealth's testimony.
That's the only testimony.
Well, no, it's not. They also have the defendant's broader statements about the collective group were
There's nothing about, they say that they don't, there's no identification of the they, there's no injection of the victim in the group, there's no mention of the victim at all. And defendant tried to run that speculative scenario through two of the witnesses, Tanya and Adolfo, and I've noted it in footnotes in my brief on pages 6 and 8, where he says, well, wasn't the whole group coming in, weren't you involved, and wasn't the victim involved, and didn't he just try to grab a knife that was on the floor and just swing and try to just make his way out of the apartment? And they both dismissed that as absolutely not. And they were firm, and the evidence, only evidence, was that the defendant was the one who initiated the verbal argument with the victim. Then during the course of that, he pushed the victim, yelled at a victim. Adolfo sees this, he comes in, he grabs the defendant, they scuffle, an insignificant fist fight. Defendant lands a couple blows, Adolfo lands 4, they fall to the floor, defendant ends up with a cut lip. There's a picture of him at booking. It's a tiny little cut lip. Defendant apologizes, agrees he's going to leave the apartment, starts collecting his belongings. Adolfo leaves, and then for 20 minutes or so, he's collecting his belongings. Witnesses see him go into his room, pick something up. He comes out of the room, victim's seated in the kitchen, in the corner, no weapons. No weapons had been used or introduced at all. And he comes out, calls her some offensive names, threatens to kill her, then takes the knife out from his side, and one witness sees him plunge it into her chest while she's seated in the corner of the kitchen. Those two girls who see that, or one doesn't see the stabbing, but they get up, they run out, he's going to stab her. 2 other girls come running in. One reaches out for the victim, sees the defendant pull something from her back. They fall to the ground in the victim's blood. And the victims then see the defendant standing over, the girls see the defendant standing over the victim. One says he's got a shiny object in his hand. The other one says his arm is raised with the bloody knife in his hand. And that's the only evidence.
If I can step back a few questions. I mean, I know it's not necessarily directly related to this case, but is the Worcester Police Department not giving Miranda still at the time of arrest?
I can't answer that definitively, Your Honor. I don't know what the timing of. Well, this was 2000. This was a 2005
Right,
incident.
but it was hours after his arrest, and he still had not been given Miranda. And an Acevedo error in 2010 that nobody spots.
I agree, Your Honor. I agree. We certainly should have objected. We did not. But I would suggest that even though the Acevedo error goes to the mutual combat and the provocation, of which there was none, and I would suggest there's no evidence of self-defense either, but the instructions as given there were, in fact, correct, even on the excessive force.
And was there any objection by the prosecutor to the giving of these instructions?
There was objected by the prosecutor to the giving of the self-defense instructions. He said on no view of the evidence, would the evidence support a self-defense instruction? But the judge gave it. And
Did you just say that the self-defense instruction was correct?
I said, yes, as far as the burden of proof, yes, I do believe so.
And also the excessive use of force in self-defense?
Yes, when he instructs on self-defense, and then he says to go back to my instructions on the excessive use of force in self-defense, or he says, go back to my instructions on the excessive use of force, and then he says the Commonwealth must prove beyond a reasonable doubt that Luis Gonzalez used excessive force in defending himself. And I would suggest I believe in the context of self-defense, that's
Okay.
true.
Okay.
I'm sorry, so you're saying that the Commonwealth has to prove beyond a reasonable doubt that he used excessive
Well,
force in
the only way you
self-defense?
get to excessive force is if the defendant used self-defense, if there was a proper exercise of self-defense.
Right.
And we're saying that, well, maybe so, but he went overboard. It was excessive. We have to prove.
But isn't the proper instruction that if the Commonwealth has proven all but has not proven beyond a reasonable doubt that he used excessive force? I mean, it seems that this is not...
It's probably not optimum, but I would suggest that it's not reversible. But in any event, it was not required. So there's no likelihood of a miscarriage of justice in this case, and there's no basis for reversal.
I guess that goes to the core issue, which is basically, I mean, do you agree that the core issue in this case is whether those statements by the defendant, standing alone, because there appears to be essentially no corroboration of them, would be sufficient for a reasonable jury to find a reasonable doubt as to those issues? Is that the core issue, basically?
Yes, I believe that is the core issue, but I also believe that the answer is no. And I think the cases that I've cited in my brief make it pretty clear. For mutual sudden combat, you need mutual sudden combat. So you need some evidence that the victim that you ultimately killed engaged in some sort of combat with you. We have none of that here. The collective they and we in the context in which it was given says nothing. The defendant could have testified, and there are cases that saying that there's nothing wrong in requiring a defendant who wants to assert a self-defense claim to actually testify. The defendant could have talked to the investigators like he claimed he wanted to and explained precisely, or not even that precisely, but just explained who they was. Where did it happen?
So you're saying it's not the fact that it comes from the defendant, it's the fact that it's so spare.
Precisely. It could come from any witness, or it could come from anything, but you can't speculate, and that's what I would suggest. That is all what we have here. You don't speculate on what the evidence might have or could have been and then get jury instructions on that. The judge erred in giving the instructions, but in my experience, trial judges often err on the side of caution, and there's a case I cited in my brief, Commonwealth versus Toon, that's an appeals court case that sort of explains that it's just, the trial judges ordinarily sometimes do err on the side of caution and give instructions, but when it gets to the appellate level, the appellate court can parse and look at the transcript to see whether or not the instructions were actually required. And that's why in Commonwealth, in Randolph, even if there's an Acevedo error, before we get to reversing on the Acevedo error, we have to first look at the evidence and see whether it was sufficient to warrant the instructions. And I would suggest that no view of any of the evidence in this case warranted any of the instructions. That may have been the only defense that the defendant had, and the judge indulged defense counsel considerably by allowing him to do it and allowing him to rate or argue the issues to the jury. And the primary issue that he argued was self-defense. But he got more than he was entitled to by all of that from the judge. And I would suggest that the facts of this case, there's nothing mitigating that would warrant this court to exercise its extraordinary powers under 33E to reduce the verdict. The verdict is amply supported by the evidence. The prosecutor's comments in closing were entirely appropriate. He didn't misstate, he didn't try to instruct the jury on eyewitness testimony. That was part of a comment on the defense. It was basically an argument, a Bowden-type argument saying, well, they didn't do any blood spatter evidence at testing. And so the prosecutor's statement was, we don't need blood spatter. We know what happened. There's blood all over the place. We have 4 eyewitnesses that can tell you there's nothing better than 4 eyewitnesses. And in context, there was nothing improper about that statement. Even this court, in Commonwealth versus Senate, and I think Wright that I mentioned in my brief, recognizes that 4 eyewitnesses makes a strong case. And I would suggest that he didn't instruct the jury on credibility He was properly commenting on the defenses, or the weaknesses, I should say, of the defenses that were suggested. Maybe he was drunk and didn't know where, there were suggestions of possible defenses thrown in there. None of them sort of materialized into a full-blown defense, but that's where the prosecutor was going there. And the prosecutor did not misstate the law on self-defense. He stated, I think, reasonably and in conformity with the law that when you stab somebody, generally when you stab somebody in the back, it's not self-defense. So I would suggest there's no basis for reversal in this case, and I would ask the court to affirm the jury's verdict.
All right, thank you very much.
Thank you.
All right.